All right. So, good afternoon, Lorraine City, Lorraine County, and anybody else who may be watching. This will be my inaugural video on YouTube here for this particular purpose. I'm going to start today's video out. I don't have live capability yet, so I'm going to be um, just one thing I've been wanting to do since day one is go over the citizens narrative that I wrote, that I sent to the city, that was a complaint against James McCann and the actions that were taken against me and my work and why I felt it was wrong, just to kind of give an explanation to everybody on exactly, what happened. So I'm gonna kind of get into it here, and we may take a couple breaks within it, but I'm gonna try to power through it. I posted links to this on all the pages, and there's links to the pages themselves within my YouTube channel. So I do plan on maybe starting a page and doing some other activities first, but this is the first step towards that. So we'll start out right here. So the citizens narrative begins, and it goes back to everything that I was dealing with James from the start. So says the following document is a statement of events and a request for this report to be sent to the prosecuting attorney for review for possible prosecution of the individuals listed. Now, as the party who was the victim of these actions, I write the following account of events under no duress and of my own free will. I do swear the following is an accurate accounting of events as they occurred to the best of my knowledge. I will attempt to break the report into abbreviated sections that can be explained in further detail upon investigation by law enforcement request. I shall lay the document out in chronological order and each attach the proof of each allegation and evidentiary attachments to be referenced as exhibits in the report. I do not make these allegations lightly, and I am deeply disappointed that I am required to do so. Below is an accurate accounting of the best available knowledge on hand at the time of the report. So, my first interaction with Chief James McCann of the Lorain County or Lorain City Police um, revolved around a civil rights violation that occurred over one of his officers denying entry to Rockin' on the River to my service animal. I started this incident because the chief made a statement in an email dated 8/4/2021 where he said, and I quote, I take all complaints seriously, but understand I cannot be involved in every aspect of this department or I wouldn't need a command staff, period. Then he goes on to state, well, please take your time and send me a well written email detailing your complaint and include the date, time, and officers' names if you know them, period. Take care. In Exhibit 1. Now, that was a perfect statement, really. The statement will be very important in establishing the motive and intent as we progress in the report. So I'm stating it now in the beginning so that you understand. So I'm going to say it again, just so we're clear. I take all complaints seriously, but understand I cannot be involved in every aspect of this department or I wouldn't need a command staff. Please take your time and send me a well written email detailing your complaint and include date and time and officers' names if you know them. Take care. That's my first exhibit. Moving forward to around March 21st, this is where I made contact with Chief McCann and Lorain Mayor Jack Bradley and others via email, where I was criticizing the departments for shutting down the Lorain City Facebook pages for police comments, and then and their handling of the incident at West 27th Street being inappropriate. Now, in the chief's response to me, he stated things like, and I quote again, the LPD cannot react to an incident on social media until we properly investigate that incident, or we would be accused of being reckless. As chief, I am well aware that a government agency operating a government social media page is subjected to legal and constitutional constraints with regards to page management. This is not, nor will it ever be, an issue for me. What is an issue is the public is under no obligation to post honest and informed content. Again, this is not an issue for me. However, harm to the reputation and, in extreme cases, the physical well-being, of Lorain Police and City of Lorain employees, as well as the organizations themselves, can and has resulted from the misinformation and inaccurate posts of these social media pages. I have personally been the recipient of threats against myself, my family, and my property. Though I am confident in my abilities to protect myself and my family, I am not okay with the LPD social media accounts being used to convey these communications or to spread the misinformation via public comment that serves as a basis for these threats. Period. To be clear, I am willing and ready to stand in front of a federal judge to state my case. Exhibit 2. Um, and I'll post a link to this report in all of the videos so you can go to the exhibits and look and read all of this yourself. As well as he stated, at this time, I quote, we have not been able to find any case law that specifically addresses the issue concerning our social media account and the actions we took to calm things down during our administrative investigation. There is, however, specific case law that does address deleting an individual's comments or deleting or blocking an individual. If you have specific case law that deals with LPD social media management decisions, I would be happy to review it, period. Additionally, courts have stated at the ACLU that off topic comments can be removed from a post. In other words, if there is a post about a basketball game, a comment that talks about a football game can be deleted. This is, of course, very time consuming. That's also Exhibit 2. Um, and so, sorry, I got a message that came in. All right. So I said I would be remiss in pointing out that if he was well aware of the policies governing social media pages, why did he need me, the social worker, to provide case law? But as you will see, I did provide him with case law in subsequent emails per his request. That's Exhibit 3. So, also sharing with me that he had received death threats as a law enforcement matter, and that should have been an ongoing investigation that I should not be privy to. Really quick, though, I am going to pop over here and see if I can find Exhibit 3. So, I believe it's pretty pertinent to the way that we read this stuff, and so this is going to be kind of boring. I apologize in advance. But I believe I responded to his email here. I'm not sure if this is Exhibit 3, but we'll read this response real quick. So, to Chief McCann, first let me start by saying I really appreciate the response, although I regret it had to be after I contacted our mayor twice about this matter. I will attempt to discuss each point you made in your response in order in the which you addressed them. One, while all of this started over the incident at West 27th Street, my concern is that the closing off of the comments being unconstitutional. I spoke with Lieutenant Morris and I voiced my concerns that the comments that he had previously been open and commented on should stay open. It is my interpretation of current case law that by shutting down comments on posts you already had open for comment, you violated the First Amendment. And while I can appreciate your want to investigate this matter, it is of no concern to me that um, in this particular matter, I did not write you about police actions that day. I wrote, called, and commented about the closing off of the constitutionally protected, traditionally public forum that I was participating in First Amendment protected speech in. The content of my speech is not to be judged, nor should it unless it falls under certain areas of threats, instigating violence, or narrowly defined hate speech. I would agree, though, if you feel you cannot manage the page, you should shut it down. To my knowledge, that is the only option, but leaving previously commented on posts shut off is the problem. In my initial contacts, I even stated that if you turned those comments back on, I would be satisfied. But then the page suddenly opened comments to the 15th of January, previous to the 15th of January, which seems strange, but it was a step in the right direction. In the end, it was about the Facebook forum being protected, not investigating the actions at West 27th Street. Number two, I'm not suggesting that you aren't the most transparent, Chief. I didn't know the previous one. Hijacked, unmanageable, none of these things mattered once you opened the page as a community public relations page. The department obligated itself to this criticism, and the First Amendment protects all citizens, not just those from who live in Ohio. I cannot say what other people would or would not accuse the police of, but speaking of an investigation or investigating the department dumped an entire history of a citizen's address with pictures of gunshots, reports to go along with it, in a Google Dropbox on the Lorain City's YouTube page, as well as on Facebook. It looks like the department had investigated a lot, and as far as I was informed by other city officials, the individuals who lived there and caused these previous crimes had since been incarcerated and is currently a resident of the state of Ohio, correct? So if you're being scared of being called reckless, why did you release all the information onto social media before you completed the investigation? Quote, as chief, I'm well aware that government agency operating a social media page is subjugated to certain legal and constitutional constraints with regards to page management. If that is the case, well, we would not be having this discussion. You state, harm the reputation, I quote. You are not reputation enforcement, and your reputation is what you and your officers gain, both positive and negative, through community interactions. If you think your department and employees' reputations are getting sullied, that sounds like hurt feelings. And we all know what the government has no feelings. You are servants, public servants, and as such, by law, subjecting yourselves to public criticism and public praise. I quote, I have personally been the recipient of threats against myself, my family, and my property. This is what James said to me in an email. I stated back in underlined format, this is criminal, and it is my understanding you have remedies under the law. You should contact the police department and report local violators or Federal Bureau of Investigations for out-of-state violations to protect yourself and your family. I would never condone such types of activities. But just because those criminals committed a crime and made terrorist threats doesn't mean I lose my rights as well. And to be clear, as I put in capitals, I would hope that you are ready to defend any actions you have undertook under the oath of office as chief of police of the city of Lorraine, as you do so under color of law. And I would hope, and you don't go around making decisions you're not going to back up. But that doesn't mean that you are correct either. I'm glad you want to protect your employee and staff's reputations as well, as the rights that you and your family have to live free without threats of violence or harm. But none of those trump the First Amendment. If anything, it only reinforces our need for protections like the First, the Second, as well as the Fourth, the Fifth, and all the amendments, really. Number 4. In your response, you wrote, many people, to include you, made up your minds about the 27th Street incident after only seeing a portion of one video and not allowing LPD to respond with the totality of all events leading up to the specific incident. This doesn't seem impartial, or at least in my opinion. Again, the public is free to form their own opinions regardless of accuracy or partiality. When misinformation or lack of information creates harm, I cannot stand idly by while social media accounts that LPD manages are used to spread outright lies by way of comments and attachments from uninformed people. You claim to be an educated social worker, but one would think that your claim of being educated, you would have the ability and the want, quote, he wrote, to get all the facts before you make assumptions or even a decision regarding what was right and wrong. My response. For the record, I have not made up my mind, but only seeing portions of one video. I watched all the videos released by your agency and the people at the address. I read all the reports put out, and based on that, plus my own knowledge and experience, I came to the logical, educated conclusion. And while it has no place in this letter, I will say your officers missed their shot. The timing was off, and once they were told to leave, they should have left and gotten their warrant. If they had waited, they had gotten their chance again legally when the juveniles left the private property. I am not arguing if the residents in that house deserve to be profiled or watched. I am not arguing your officers or the ATF did anything wrong in this letter or complaint. Did I offer opinions online? Yes, but that doesn't mean that I've made up my mind about anything. Yes, I made a claim of being educated. Sarcasm noted. Yes, I would love all the facts. I thought reading the dossier that you put online was enough to educate me. But sure, I would never want to make assumptions. I also wouldn't want to shut down reasonable conversations on a public forum I opened to try and get that point across and then close it with no explanation. You put the information out there on Facebook and then got mad when people didn't just see it your way. Government officials may have no obligation to open the social media account up for public comment. But if they do, they cannot discriminate as to which views get to be expressed in those comments. And that's okay as well. And you have a right to be mad. But the Facebook's page has no feelings, nor does the Lorraine Police Department. You want to make this about the incident at 27th Street, and I simply am stating that you violated my First Amendment rights by stopping the conversation. 5. As far as the case law goes, I supplied it in my official complaint, but I'll do so once again here and provide it for your convenience. The Knight First Amendment Institute versus Trump in 2019, where the Second Circuit issued its decision in 2019 upholding the district court ruling. The Second Circuit determined that Trump used his Twitter to conduct official government business and therefore he cannot block Americans from the account on the basis of their political views. The Knight ruling has been cited as an important development in the use of social media as a public forum and the tendency of government officials to try to block access to forum or delete past communications. Davison v. Randall in 2019. They decided in January 7th of 2019, a panel of the Fourth Circuit unanimously held that interactive component of a local government's official Facebook page constituted a public forum, and that the official engaged in unconstitutional viewpoint discrimination by banning Davison from the forum. Swanson v. Tilbrook Griffin, 2022. Swanson sued Griffin and the Ontario County Records custodian Sylvia Tilbrook, alleging that Griffin's Facebook page was a public forum, that Griffin had violated the First Amendment by engaging in viewpoint discrimination. Peckingham v. North Carolina, in which Anthony Kennedy described social media as, and I quote, the modern public square, end quote, and as such, one of the most important places for the exchange of views. In Cohen v. California, the court held that early in the case, that interactive comment section of the state's police Facebook page is designated public forum. Profanity usually doesn't justify governmental action against speech in a public forum. Biden v. Knight, First Amendment Institute, Columbia University. At the time, I couldn't find a lot on that one. I believe there's more out now. You can look it up if you want. I'll give you case number on this one because I didn't provide a detailed description. It's 141 S.CT.1220, and then in parentheses 2021. You'll also find it in the links that I attached to this. And so it's then we have City of Houston, Texas v. Hill. The First Amendment protects a significant amount of verbal criticism and challenge directed at police officers. Garcia v. City of Trenton, an adverse action that would chill a person of ordinary firmness from continuing in the activity. This is an important one here. Garcia v. the City of Trenton, an adverse action that would chill a person of ordinary firmness from continuing in the activity. The United States District Court for the Eastern Division of Arkansas ruled that the Arkansas State Police unlawfully used Facebook content moderation tools to censor speech of the Facebook department's Facebook page. The agency set Facebook's profanity filter, which deletes comments if they contain certain objectionable words, at the strongest available setting, and blacklisted a set of custom words that they included pig, copper, and jerk. But people are free to say those words, wrote Chief United States Justice District Judge D.P. Marshall Jr. in the court's opinion. The First Amendment protects disrespectful language. This is why I've been using it lately in my videos when I never did before. I don't necessarily like using it all the time, but I'm trying to get the point across. So then I wrote this to James. Playing devil's advocate. I have found some research on this matter as well. The primary approach an agency has in this scenario is to have a policy carefully vetted, by legal counsel that sets forth what comments are authorized and what are not. For example, the policy can specify that obscene, defamatory, and other similar types of comments are not permitted. The policy can also specify that comments have to relate to the matter originally posted in the example above, the officer's promotion. But that policy itself presumably must be designed to satisfy the stringent demands of forum analysis, including that the policy must be viewpoint neutral and that the agency must be able to justify its restrictions on certain types of comments in a way that will satisfy forum analysis requirements. The 2015 Walker decision described above is an important one because it offers agencies a possible way out of the strictures of forum analysis in the maintenance of government social media accounts. Obviously, I'm quoting this from other stuff. I looked this up. That's what's talking about these other cases. So with government speech, the government has a significant latitude in the message it conveys. And if what is at issue is not a forum, but instead government speech, the government has substantial authority to limit this message being conveyed. Government speech is an alternative way of viewing the scenario. If the court if it asks the court to view an agency's social media site not at the hosting of speech by members of the public, subject to certain rules, but instead the government itself speaking by effectively selecting comments posts to offer to the public and choosing not to offer others. So under the Walker decision, I would agree that you would have the right as an agency to restrict posts and comments. But the problem is that wasn't what the department chose to do originally. My understanding is under the Walker decision, the department would be correct if, and only if, the department had never made the page about posting facts. Or the department had always made the page about posting facts and information and had never allowed comments. Two, never posted the entire scenario online for the public comment, thereby inviting the public criticism. The incident at West 27th where they posted all that kid's information, we'll get to that later. That's probably a different video. So had in place a legally vetted social media policy that clearly defined what counsel and could and could not be posted on the page. So had a placed a legally vetted social media policy that clearly defined what could and couldn't be posted on the page. That was posted for public review. 4, had never utilized the page for any other purpose other than to do anything beyond providing basic public information. And so and I said here, I'm not an attorney, so I would obviously want you would obviously want to consult with one because I'm unable to give legal advice. I can only act in accordance with my own legal rights on the First Amendment claim alone. But I would be worried that if we were speaking hypothetically and say a public official discontinued comments on a public forum based off of the possibility of, quote, harm to the reputation and one second. All right, sorry about that. I never used the page for any other purpose other than as a forum to do so beyond provide basic public. Oh wait, no. Oh yeah, we were at the quote part. So based off the possible quote harm to the reputation and extreme cases the physical well-being of the Lorain police and the city of Lorain employees as well as the organizations themselves can have resulted from the misinformation and inaccurate posts on these social media pages, end quote, by James McCann. That could be viewed as retaliation and as such could be considered problematic as, and I quote, an act taken in retaliation for the exercise of a constitutionally protected right is actionable under a 1983 claim, even if the act, comma, when taken for a different reason, comma, would have been proper. See Deloach v. Beavers 922, as well as quoting Matzer v. Herr 748. Moreover, the unlawful intent inherent in such a retaliatory action places it beyond the scope of, in block parentheses because it's assuming the quote, of an official's qualified immunity if the right retaliated against was clearly established. And so, you've got in Deloach, it's that. And so, but again, I'm not an attorney, so I'm unaware if any of that is the case, nor am I able to provide you with legal advice, is what I said in the letter. And then he was being snarky back, so I said, finally, I only sent the email to Marcy Kaptar out of a connection I'm formed with her while working on the veterans issues in the state of Ohio. I do realize she's no longer a local rep, but as I follow all state and local politics, and I like to keep people in the loop as Ohio is a small community. And as she was our representative for many years and could be again based on how we move districts around unconstitutionally and require the Ohio Supreme Court's involvement, so that was merely for her information. But I appreciate the attempt to inform me of our current congressional district's representative. It's Bob Latta, but I wasn't trying to involve his office or Congresswoman Kaptar officially, which is why I didn't specifically mention them in my email request. I am unsure what you mean by, quote, inappropriate FOI request, end quote. If you're referring to the form I used, it was the only one you had available on the website to release information. I realized that the old chief's name was on it, but it was what the department offers to the public as an outdated website the department currently has up. If you're referring to me asking for communications between my government officials and attorney-client protected, I would advise that only direct communication between you and your lawyer are covered, and as such, any emails to anyone who isn't a police department lawyer would be accessible under the FOIA request. Such information could include any emails between you and Lieutenant Morris in regards to the Facebook situation, any emails and communications with officers about the Facebook page, and policy letters or memos in regards to the Facebook page. To my knowledge, none of these have been protected, and under the attorney-client privilege and by law, you can annotate any names or personal information. Now, I came to find out later he was beefing on the FOI stuff because he was nitpicking them, saying, "Oh, you didn't say it's sunshine laws in Ohio." Well, in Idaho and in California, it's Freedom of Information Act, and federal government, it's FOIA. So I was unaware, so he was being, I just didn't get it because I didn't realize he was being snarky. This was early dealings with him. In conclusion, I would have been satisfied if you just had left the post you previously opened for comment open. I would have appreciated an earlier response with less snarkiness and a little respect, but I suppose that was way too much to ask as well. To be clear, I'm only concerned about the First Amendment and the fact that you closed out comments on posts you previously opened and engaged in conversation with the public, only to close them off when you didn't like what was said. As far as whatever garbage fire your department has gotten themselves into over the House, that's not really my concern. As you pointed out, that's a matter for the prosecutor's office to decide. The government has no feelings. Your police page is a government page. I would argue it has no feelings. And you should choose to just ignore the comments or go about your day instead of being sad and then turning off comments. It's just a bad look, but to each their own. But again, this is just one citizen's opinion sprinkled in with some case law. And then I wrote insist a permitter, Aaron Knapp, LSW, CDCA, because, that's he was using his Coast Guard motto at the bottom of his page for a little while there, and I was being a little petty too. And I wrote it to stay for mitters. So, but anyway, back to what we were saying before. So I believe we left off operating government agency. So he writes. It continues to write on April 10th. I received the following email response. Oh wait, I wrote on April 10th. I received the following email response from James McCann in response to the complaints contacting my employer and that I made to the mayor. Now, that my first time, basically, I went to the mayor's office. I made a complaint. I had only been there. That was my first time going to City Hall. Was back on in April, back in April, and I talked to Mayor Bradley and his chief Soto guy, and then was quickly escorted out of a back door. It was the only time I'd ever been in City Hall, and so I said someone had called my place of employment. Now I come to find out from my boss that later that it had just been rumors. People had been talking, and it got back to my employer. But because of all the other interactions, it looked like James had done it. And again, he later did do it. So I mean, this is why this important point is when I thought he did it or someone did it, and they said no one did it. James responded, and I quote, with, "If someone called your place of employment in their official capacity from the Lorain Police Department, they were not authorized to make such a phone call or notification. If you have proof of this accusation and the name of the employee, please forward it to me and it will be investigated. If it can be determined that a member of the police department in their official capacity called your employer, I will address it. You filed your complaint with the U.S. Attorney's Office, not the Lorain Police Department. The matter is in their hands. Exhibit 2. So on May 8th, I received a response from Chief McCann that stated the following. First, I will address your email from May 7th at 0800 hours. I feel the need to help you understand what a public record is. According to the Ohio Revised Code, a public record means any document, regardless of physical form, including an electronic record created or received by or coming under the jurisdiction of any public office to which this serves document to lead activities of the office. Oh, all right. Hold on a second. All right. And so then it says, you have not asked for any public records in your email. You have asked for legal advice, which we do not give. Your question should be directed to your attorney. Second, I will address the complaint you filed May 8th. There is no violation of law. We are within our rights to release the information. The complaint will not be investigated. This was in reference to me saying that they released everything. And again, the link's still up. They released this juvenile's information, and they released court documents that weren't supposed to be released. The parent stuff I can't argue about, but the kid stuff should have never been online. And that was my big thing. Like, we don't punish the kid for the parents. Um, It's your right to file a lawsuit, but I would strongly suggest you speak to your attorney and ask him to explain the consequences of filing frivolous lawsuits and the potential repercussions that can come from them. And then he states, quote, no one here believes a simple forwarded email with no additional comment is a public record, period, or comma, but I will also include that as a PDF, Exhibit 4. And then on 6/24, he wrote an email correspondence to me and CC'd the executive officer. Said, Mr. Knapp, B, lower the answers to your questions. Okay, well, at a minimum, I would think I would have access to the new policy as it was read to me via phone, via the entry to City Hall. Okay. So this is when I tried to enter City Hall. You guys have seen that video where I've done an overlay. I think it's on another channel. I may have to share it. I don't know. But so I was trying to enter City Hall. It became a big debacle, and so this was the response. Okay, well, at minimum, I would think you would have access to the new policy that was created and read to me via phone about my entry into City Hall. As it's a policy, it shouldn't be restricted. And he responded with, the Lorraine Police Department is not in charge of security protocols for the City Hall, nor do we make the policy for City Hall. The Safety Service Director is in charge of City Hall. For the record, I'm not sure how to access the public lobby videos or videos would be privy to protection under this law. That being said, can you give me a time frame on when they will be available? I think this is me responding. You have 30 days to complete your investigation of the lieutenant placing his hands on me. I assume I'll receive them. He responded back, you are entitled to your opinion. During an active criminal or an active administrative investigation, we believe video evidence is not public record and the investigation until the investigation is completed. That's important too, because they still haven't provided videos of other investigations they've completed. So they do what they want when they want. Um, if you disagree with us, you have that right. You also have the right to file whatever action you desire. Just to be clear, the 30-day deadline is an internal policy that I set as a general completion goal and may be extended to any time depending on operations, complexity of the investigation, vacations, and the like. Convenient. Are you planning on charging him with a crime? I wrote, because as I read here, I am the subject of the video and I have a right to have access to his body worn camera regardless of your investigation into the lieutenant's actions. He said the administrative action investigation is ongoing. Again, we believe the video evidence is not public record until the investigation is completed. Then the last statement about the administrative investigation being ongoing and not public record until completed is very important. At this later, this very report was sent to a civilian, that would be Tim Weitzel, via email prior to the investigation being completed. On or around late May, Chief McCann filed a complaint against my state license to practice social work. And in late May, on behalf of the Lorraine Police Department, for signing LSW to my emails and then stating I was an officer of the court on May 9th contact. So in Exhibit 5 in my message, you'll see I felt it was inappropriate for myself and the chief to have continued contact. I sent him several emails asking him to cease all contact with me. On June 21st of 2023, I sent the following email to the chief in response to his continued email communication. And after I'd asked him to stop, the following is the email he sent on 6/21 where I asked the chief to stop all communications with me. I'm going to stop and get a drink after I read this. So I said, please, I will ask you once again not to email me. If you wish to communicate with me, I'd appreciate it if you would place said communication into writing and mail it to me. I'm not sure why my request for records would be subject to a response from the chief. If you're referring to the state investigation into my license, I see no law preventing me from having the email as you are not that agency, and you did send it. But if you wish to hold off until the board is done, by all means do so. As Captain Mathewson reviewed those policies with me and read them to me over the phone, the department obviously received the memo on security, because they made this new security thing where we had to sign in to enter City Hall, but they created it the day after I had my little incident with Swanger. And so they read it to me on the phone like I was a child, but then they didn't want to give it to me. And so he says, if you're referring to the state investigation, I said it in my license, I see no law preventing me from having the email, as you are not the agency and you did send it.
because I thought because he sent it to his city email, I could have it. I still believe that. Like, while I believe the board can't release it to me, I believe the second he sent it via city email, it opened it up to request. So while I can't see it, anyone else should be able to request his email complaint that he made about my board and get it. Like, any citizen should be able to ask for that. Hint, hint. So maybe if one of you guys call and ask for the complaint that James McCann made against my board and licensure, he would be forced to release it to you if they sent it via city email address. Hint, hint. You could just write an email that said, "I'd like to request the complaint that James McCann wrote to the marriage counselor and licensing board. That was a complaint against Aaron Knapp's licensure. And since I'm not Aaron Knapp, I'm allowed to ask for it because I'm not the person. And this was sent via a city email address, makes it public record. That's why I keep telling them they gotta redact, annotate, block, secure. Anyway, back to the story at hand. Um, So I'm not sure why you're being so secretive about all this stuff. So therefore, it's part of the internal records and was sent via email to at least two separate captains who read it verbatim to me as if I were a child. So I'm not sure why you've been so secret about all this stuff. But in the future, if you have to email me, I would please request that you have Captain Matthewson respond. He has been respectful and responsive, and I think it's very bad idea for both of us to have continued conversations. So please let the officers do their jobs and respond to me. I'm trying to follow the appropriate procedures here, and that requires I send my emails to the appropriate people. You make it a wonderful day as well, because he started copying my "make it a wonderful day," because I was copying his little using my Latin motto. We were both being kind of childish at this point with the email sign offs. I guess that's how intelligent people fight. I'm not saying James isn't an intelligent man because he's playing a good game here. And honestly, in any other case, I would respect the hell out of his battle plan. The way he operates, probably the reason why I don't like it is it feels a lot like the way I operate. But I'm not a chief of police, like I'm coming at this from a different standpoint than he is. Aaron Christopher Knapp, Exhibit 6. So I wrote the letter. Chief responded with, "Mr. Knapp, now I'm going to pause this and I'm going to go get something to drink and I will be back. So if I seem a little different when I come back, you'll know why, but I'll be right back."
All right. I know for you, just a second. It's been a few minutes for me. So I left off at the base of this other page, which was Mr. Knapp. The chief is responding. "Thank you for your response. Email is my chosen form of communication to reply to you and all the public information requests I receive from everyone, so this is what you get. You get the response from me because your requests are not the type of requests that our records employees handle. And I will be the only one to respond to all your requests from now on. Our records employees do not have access to email records, video, or other administrative files, so the requests are all forwarded to my office. It's great that Captain Matthewson reviewed the City Hall policy with you. However, the policy is not ours to release to the public. Policy was issued by Safety Service Director, and that is whom you need to request it from. If we were trying to be secretive about the policy, I wouldn't have told you where to request it from. Finally, you don't get to demand who you talk with at Lorain PD. I get to make those decisions, so I will be the only one communicating with you from this department in the future." Let's let that sink in. You don't get to demand who you talk to at Lorain PD. I get to make those decisions. So I will be the only one communicating with you from this department in the future. So I only get one law enforcement officer. That's what my tax dollars paid for. I get James McCann. That's it. No other services. And let's mind you that later Ray backs that up by saying sometimes it's the asker and not the ask. And then he writes, have a great day. So if we refer back, though, I remember I told you at the beginning of this, we refer back to the beginning of the report where he states in an email, he says, 2 years later, back 2 years prior, he stated, "If I take all complaint," no, he says, quote, "I take all complaints seriously, but understand I cannot be involved in every aspect of this department or I wouldn't need a command staff. Please take your time and send me a well-written email detailing your complaint and include the date and time, the officer's name if you know them. Take care. He cannot be involved in every aspect of this department. Now, he wouldn't need a command staff, but yet here he is here telling me that I'll only speak to him. I don't get it. So again, he says his chosen form of communication was email. So I said his chosen form of communication does not matter. I was sending my emails to the Lorraine complaints email. Captain Mathewson had already been designated my contact point, so why the change? Either way, I asked him to stop, and he refused. Now, under Ohio Section 2917.21, telecommunications harassment, the Ohio Revised Code states that knowingly making telecommunications to a recipient of a telecommunication to another person as the premises to which the telecommunication is made, or to those premises, and the recipient or another person at those premises previously has told the caller not to make a telecommunication to those premises or any persons on those premises. Whomever violates this is guilty of telecommunications harassment. A violation of Division A, and then it lists 1, 2, 3, 5, 6, 7, 8, 9, or 10, or 11, 12, or B of this section is a misdemeanor of the first degree on a first offense, and a felony on the fifth degree on each subsequent offense. So, under this law, the chief's first response on 6/21/2023 would have been offense number 1. There were at minimum 2 more plus responses buried in the chain of emails once he was asked to cease electronic communication with me. I have emails then from August 1st and August 16th that I didn't reply to from the chief. That would make the count second 2 offenses, felonies of the 5th degree each. All this started over the chief refusing to remove protected public information from Lorraine's police website. After reporting this to numerous individuals who agreed at the juvenile court that juvenile court documents and pictures of juveniles, especially those not subject to arrest, are not permitted online. I wrote an official complaint to the department asking them to remove the offending documents, but they refused. And to date, Mayor of Lorraine Jack Bradley and the chief claim they have the right to post juvenile information publicly online, not to mention the teachers' names and all of the information that was supposed to be protected under FERPA. Now, documents have all been posted to boot. Now, here's the kicker. Those are not my kids, and as such, I cannot sue civilly on behalf of the parents. Can't be me. Parents have to do it. That would be the Hildreths. But in this matter, but as a matter of public concern, I can advocate to get the information removed as it is illegally online unredacted. My statement is that if the chief believes he has the right to share the Hildreths information publicly, then why wouldn't he share my child's information or any of your children's information if he so deemed that it would give him his way with you? Fast forward to our current, and James McCann submitted over 61 pages of email complaints, confidential administrative screens, addresses, phone numbers, last 4 of social, child's name, everything via unsecured, unredacted public email to Tim Weitzel, the juvenile court administrator, Exhibit 7. Now, Exhibit 7 is important because I posted Exhibit 7 a bunch of times, and Exhibit 7 is copies of James's text messages where he's basically telling Tim Weitzel everything and sending it to him. And so basically, he states in the email, well, he doesn't basically, I quote in the first email, he says, quote, Tim, keep this close to the vest as this is still under investigation, end quote. So he sent confidential law enforcement investigatory records. Remember when I talked about that earlier? To a civilian. Basically, yes, Tim Weitzel works as the director of the juvenile courts, but he had no right to this knowledge or this information. And even if he did, why wasn't the chief sending it officially? Why was he sending it through backdoor channels, not redacted, not blocked out? Anyway, so the more we look at this, again, he says, Tim, keep this close to the vest as it's still under investigation, knowing damn well he shouldn't have shared it. So, is Tim Weitzel a police officer or prosecuting attorney? Does he have access to Lorraine police records on call?
And should he receive documents from the city of Lorraine's police chief illegally, as they contain witness information as well as my information? And under the law, I'm considered a protected individual as I am working as a social worker in juvenile justice. So sharing all of my private information was illegal under the following laws. And I'm going to quote the laws on the next page. I just want to point out that Tim Weitzel is the director of the juvenile court, or the juvenile court administrator. He runs our juvenile court jail and is the administrator for that side of things. But he is also a licensed social worker, master level. I did not realize it in the beginning. So he is above me in the professional chain of command as far as social workers are concerned. That concerned me because he should have had my back. He should have supported me. He should have been like, hey, you know what? Like, and engage with me and advise me why he felt I was doing something wrong. But in the end, the NASW found me to be, have done the right thing ethically. So, but Tim didn't, and that's a problem because he's a social worker. So under the following laws, so here we are at the next one. Section 149.43, availability of public records for inspection and copying. Ohio Revised Code and Title I, State Government, Chapter 149, Documents, Reports, and Records. As used in this section, 1, a public record means records kept by any public office, including but not limited to state, county, city, village, township, and school district units, and records pertaining to the delivery of educational services by an alternative school in the state kept by a nonprofit, for-profit entity operating the alternative schools pursuant to 3313.533 of the Revised Code. Public record does not mean any of the following. So, clears, confidential law enforcement investigatory records. Now, the funny thing about clears is, and I think we'll talk about this later, is that clears are only clears while the investigation is ongoing. The second the investigation ends, it's no longer clears. So at that point, the public has access to them. Also, it's important to note that clears is only clears when the video is in the hands of the police. So, for instance, if I have a copy of the video as an agency, say I'm a state agency, and I videoed someone in my lobby doing dumb crap, and then the police came and arrested them, and they took that video, and they used that video in their criminal prosecution. When I ask for it from the police, they have to say no. When I ask for it from the agency, they still have to say yes, because it's still a matter of public record from the agency. It's just about who gives it, not about the document. It's about who's giving the document for liability purposes. Designated public service worker, residential and family information. Now, I kind of felt like that was me. I've argued this, but whatever. Records, the release of which are prohibited by state or federal law. Confidential law enforcement investigatory record means any record that pertains to law enforcement matter, criminal, quasi-criminal, civil, or administrative in nature, but only to the extent that the release would create a high probability of disclosure of any of the following. The identity of a suspect has not been charged with an offense to which the record pertains, or an information source or witness to whom confidentiality has been reasonably promised. I feel like that was reasonably promised in the complaint form that James gave us. Information provided by a source or witness to whom confidentiality has been reasonably promised, which information would be reasonably tend to disclose the source's or witness's identity. Like, I was the witness. I was giving these complaints. You disclosed my identity to my employer to get me fired. Yeah, you did some other stuff in there, but designated public service worker. Now, we've talked about this. Means police officer, parole officer, probation officer, bailiff, prosecuting attorney, prosecuting assistant attorney, correctional employee, county or county corrections employee, community-based correctional facility employee, designated Ohio National Guard member, protective services worker, youth services employee. That one's important because while they'll say that they're not youth services, the Lorain County website literally said youth services on it. And they're claiming that state youth services. Well, it doesn't say that in the law. It says youth services employee. So I work for juvenile justice. Where's that? I leave off at National Guard and Youth Services. Firefighter, EMT, medical director, or member of a cooperating physician advisory board. An emergency medical service organization, state board of pharmacy employee, investigator for the Bureau of Criminal Investigation and Identification Investigation, emergency service telecommunicator, forensic mental health provider, mental health evaluation provider. I did that for the county. That's literally what I did. Regional psychiatric hospital employee, no. Judge, no. Magistrate, no. Federal law enforcement, no. Information that does not constitute a confidential law enforcement investigator record that could identify a person who provides sensitive or confidential information to the Department of Rehabilitation and Correction, Department of Youth Services, or a law enforcement agency when the disclosure of person's identity and information provided could reasonably be expected to threaten or endanger the person's safety or property of the person or another person. Personal information of a person who was not arrested, cited, charged, or issued a written warning by a peace officer. I wasn't arrested, cited, or warned. Like, he shouldn't have been sharing any of that. Offenses against justice and public administration and general definition. No public servant under color of law of the public servant's office, employment, or authority shall knowingly deprive or conspire or attempt to deprive any person of a constitutional or statutory right. Whoever violates this section is guilty of interfering with the civil rights and a misdemeanor in the first degree. Section 2921.03 of the Ohio Revised Code talks about intimidation. No person knowingly, by force or unlawful threat of harm to any person or property, or by filing, recording, or otherwise using a materially false or fraudulent writing with malicious purpose, in bad faith, or in wanton, reckless manner, shall attempt to influence, intimidate, or hinder a public servant, a party official, an attorney or witness, in a civil action or proceeding in the discharge of the person's duties, or the public servant, party official, witness, attorney, or witness. Whoever violates this is guilty of intimidation and felony in the third degree. Person who violates this section is liable under civil action to any person harmed by the violation for injury, death, loss to a person or property incurred as a result of the commission of the offense, and for reasonable attorney fees, court costs, and other expenses incurred as a result of proceeding the civil action concerned commenced under this division. A civil action under this division is not the exclusive remedy of a person who incurs injury, death, or loss to person or property as a result of the violation of this section. And then another section is Department of Justice Administrative Services personnel definitions, and then it's pretty much just going on. So Department of Administrative Service personnel definitions. Civil service includes all offices and positions of trust or employment in the service of the state and in the service of communities, counties, cities, city health districts, general health districts, and city school districts of the state. State service includes all offices and positions in the service of the state and the counties and general health districts in the state. State service does not include offices and positions in the service of the city health districts, or city school districts of the state. And again, as the chief stated himself in regards to the investigation concerning Mr. Knapp, or concerning City Hall, Mr. Knapp, due to the ongoing administrative investigation, the records have requested are not currently subject to disclosure, and records are confidential law enforcement investigatory records pursuant to RC 149.43A1H. Your request is denied. Also, when Chief sent 61 plus documents, Exhibit 7 to Tim Weitzel, he was utilizing email to not only commit retaliation, but retaliation 2921.05, but offenses against justice and or public administration 2921. No officer, employee of the state, or any of its political subdivisions shall knowingly release, disseminate, or make available any purpose involving employment, bonding, licensing, or education to any person or to any department, agency, or other instrumentality of the state or any of its political subdivisions, any information or data concerning any arrest, taking into custody, complaint, indictment, information, trial, hearing, adjudication, or correctional supervision, the records of which have been sealed pursuant to 2151.356 of the Revised Code, and the release and dissemination of making available which is not expressly permitted by this section. Whoever violates this section is guilty of divulging confidential information, a misdemeanor of the fourth degree. No person shall purposely and by force or by another threat of harm to any other person shall retaliate against a public servant or a party official or an attorney or a witness who is involved in a civil or criminal action or proceeding because the public servant, party official, attorney, or witness discharge the duties of the public servant, party official, attorney, or witness. I'm telling you, it's like it's my ethical code to report, be a mandated reporter. Whoever violates this is guilty of retaliation, a felony in the third degree. He also continued his telecommunication harassment by Mr. Knapp through another individual, which is a violation of Section 2917.21, telecommunication harassment. 5. Knowingly makes the telecommunication to the recipient of the telecommunication to another person at the premises to which the telecommunication is made, or to those premises, and the recipient of another person at those premises previously has told the caller not to make telecommunications to those premises to any persons on those premises. Knowingly incites another person through a telecommunication or which means to harass or participate in the harassment of a person. When he sent the email to Tim Weitzel, that's what he did. He knowingly incited another person through a telecommunication or another means to harass or participate in the harassment of a person, me. Whoever violates this is guilty of telecommunication harassment, a violation of Section A 1, 2, 3, 5, 6, 7, 8, 9, 10, or 11, or B of this section is a misdemeanor in the first degree on the first offense and a felony on the fifth degree on the subsequent offense. The key part, the part that is key, is I lost my job. It cost me approximately $12,800 in salary, and that's not counting the benefits and finding new work. Read this part very carefully and look at what the dollar amounts due to the charges. It says, except as otherwise provided in Division C3 of this section, a violation of Division A4 of this section is a misdemeanor of the first degree, of a first offense, and a felony of the fifth degree on each subsequent offense. If a violation of Division A4 in this section results in economic harm of $1,000 or more, but less than $7,000, 500, telecommunication harassment is a felony in the fifth degree. If a violation of Division A4 of this section results in economic harm of $7,500 or more, but less than $150,000, telecommunications harassment is a felony in the fourth degree. If a violation of the division of this section results in economic harm of $150,000 or more, it's a felony in the third degree. Now, I attached all the exhibits to the report. I also included other laws that are applicable to the report and or crimes, and I will expect any and all questions will be asked and answered during the investigation into this matter. It should be noticed that upon receipt of the emails, Tim did not keep it close to the vest. He acted on it and shortly thereafter verified that Mr. Knapp was a guardian ad litem and under the Lorraine Court's own website was considered an officer of the court. He had Mr. Knapp's ability to contract with the courts terminated for supposedly misrepresenting the court, which is the same thing McCann stated. And then he also shared this information with other employees in the court, such as Tim Green for Voices for Children, and instructed him not to speak to me or allow me to volunteer with the courts. Again, more legal actions on the evidence that arguably were fruits of the forbidden tree and should never have been should have been immediately reported to the courts once it was received from the chief by Tim. The guardian ad litem completes 30 hours of pre-service training, which includes 4 classroom sessions of 30 hours and courtroom observations. All gals are screened, interviewed, and a criminal background check through the web service system is completed. The judges administer an oath, and the volunteers are then recognized as officers of the court. That's from their own website, which they recently changed. I still have photos of the old and the new. In addition, there is a continuing 12-hour education required annually. It is misconduct and grounds for discipline for the GAL too, and then it goes through like violate or attempt to violate the rules governing the guardian ad litem status or appointment under the items pursuant to them, knowingly assist or induce another to do so, and as though the acts of the another engage in conduct that violates and the applicable rules of conduct for GAL's guardian ad litem in another jurisdiction, commit any criminal or unlawful acts that reflect adversely on the GAL's honesty, trustworthiness, or fitness as a GAL, engage in conduct involving dishonesty, fraud, deceit, or misrepresentation, have allegations of abuse or neglect against them substantiated by, I wrote Maine, by the Department of Health and Human Services, failed to maintain compliance with requirements for placement on rosters of guardian ad litem's names in the performance of the guardian ad litem's duty by words of conduct manifest bias or prejudice against one's race, color, religion, national origin, disability, age, sexual orientation, or socioeconomic status, willfully violate an order imposing discipline upon a guardian ad litem's rules, or willfully fail to comply with the subpoena validly issued by the courts, or knowingly fail to respond to any lawful demand from a disciplinary authority except that the guardian ad litem is not required to disclose information that otherwise protect applicable rules relating to confidentiality, or fail to comply with conflict of interest mandatory disclosure requirements in all guardian ad litem rules. Basically, you got to report everything and you got to be a goody two shoes. Should be noted that the social worker board found that I was I acted ethically. That's Exhibit 8. It should also be noted that the Ohio Department of Unemployment found I acted appropriately and did not violate the ORC Exhibit 9. In fact, it said that Applewood violated the ORC when they terminated me. So, laws of reference: confidential law enforcement investigatory records are not considered public records pursuant to Ohio Revised Code 149.43. The exemptions of public records being public servant information as well as witness information. Also attached will be Exhibit 10, Mr. Knapp's response to the Lorraine police complaint set within the attachments. I read that. Section 2151, duties and powers of probation department records command assistance. Title 21 of the Courts and Juvenile Chapter 2151, which states in accordance with the division of this section, subject to the limitations specified in the division of this section, and in connection with the disposition pursuant to Section 2151354 of the Revised Code, when a child has been found to be an unruly child, a disposition pursuant to 2152.19 and 2152.20 of the Revised Code, when a child has been found to be a delinquent child, or disposition pursuant to items 2152.20 or 2152.21 of the Revised Code, when a child has been found to be a juvenile traffic offender, the court may issue an order requiring boards of education, governing bodies, chartered non-public schools, public children's services agencies, private children's agencies, probation departments, law enforcement agencies, prosecuting attorneys that have records related to the child and its question to provide copies of one or more of the specified records, or specified information in one or more of the specified records that the individual or entity has with respect to the child, and in the following individuals or entities request the records in accordance with Division D3A of this section. The child, I know, bear with me, over an hour at this point. The attorney or guardian ad litem of the child, a parent or guardian ad litem of the child, the prosecuting attorney, the Board of Education of a public school district, the probation department of the juvenile court, a public children's services agency, or a private placement agency that has custody of the child, or is pending providing services to the child or their family, or is preparing social history, or performing any other function for the juvenile court. The Department of Youth Services, when the department has custody of the child or is performing any services for the child or are required by the juvenile court or by statute. The individual in control of the juvenile detention or rehabilitation facility of which the child has been committed. An employee of the juvenile court who has found the child to be an unruly child, and a delinquent child, or a juvenile traffic offender. Any other entity that has a child, has custody of the child, or is providing treatment, rehabilitation, or other services for the child pursuant to the court order, statutory requirement, or other arrangement. An individual listed in the divisions above of D1A2K of this section may file a motion with the court to request the court issue an order as described in Division D1 of this section. If a motion is filed, and the court shall conduct a hearing upon it, if at the hearing the movement demonstrates a need for one or more of the specific records or information in the specified records related to the child in question, and additionally demonstrates the relevance of the information sought to be obtained from those records, and if the court deems that the limitation specified in D4 of this section does not preclude the provision of a specified record or specified information to the movement, then the court may issue an order to a designated individual or entity to provide the movement with copies of one or more of the specified records or with specified information contained within the specified records. In this case, a grand jury was conducted allowing access to the records that the police had. So they had every right to have the Hildreth school records and all of that. Like, the police had every right, as did the courts, and everyone else had. We all had a right to have access to it. What we did not have access to do was disseminate it to the general public. It says here 3A. Any individual or entity that is authorized by order pursuant to Division D1 of this section to obtain copies of one or more of the specified records or specified information related to a particular child may file a written request for copies of the records for the information with the individual or entity required by the order to provide copies for the records or the information. The request shall be in writing. Describe the type of records and information requested and explain the need for the records or the information and be accompanied by a copy of the order. If an individual or entity that is required by order pursuant to D1 of this section is to provide one or more of the specified records or specified information related to a child, receives a written request for the records or information in accordance to section D3A of this section, the individual or entity immediately shall comply with the request to the extent they are able to do so, unless the individual or entity determines that it is unable to comply with the request because it is prohibited by law from doing so, or unless the requesting individual or entity does not have the authority to obtain the requested records or information. If the individual or entity determines that they are unable to comply with the request, it shall file a motion with the court that issues an order requesting the court to determine the extent to which it is required to comply with the records request for information for the records or information. Upon the filing of the motion, the court immediately shall hold a hearing on the motion to determine the extent to which the movement is required to comply with the request for records or information and issue findings of fact and conclusions of law in support of its determination. The determination of the court shall be final. If the court determines that the movement is required to comply with the request for records information, it shall identify the specific records or information to be supplied and to the individual or entity that requested the records or information. If an individual or entity is required to provide copies or one or more specified records pursuant to Section D, Division D of this section, the individual or entity may charge a fee for the copies that does not exceed the cost of supplying them. Division D of this section does not require, authorize, or permit the dissemination. This is an important part of all of this. So, did Lorraine police have the right to have that kid's records, the Hildreth kid's records? Yes. Legally, they got it through a subpoena and everything. The question is, did they have the right to post it online for all of us to see through that link? That answer, I believe, is definitively no. So, here, Section 4, Division D, specifically states of this section that it does not require, authorize, or permit the dissemination of any records or any information contained in the records if the dissemination of the records or information generally is prohibited by provision of the revised code, and specific provisions of the revised code does not specifically authorize or permit the dissemination of the records or information pursuant in Division D of this section. Again, Division D does not require, authorize, or permit the dissemination of any records or information contained in the records if the dissemination or records of information generally is prohibited by the provision of the revised code, and use a specific provision of the revised code does not specifically authorize the permit the dissemination of the records or information pursuant to Division D of this section. That clearly shows that while the police had access to the documentation for the school as well as the juvenile court due to the order generated by the grand jury that required those entries to turn entities was what it's supposed to say, to turn those documents over for the purpose of investigating being conducted, it clearly did not give the Lorraine police the right to publicly disseminate the records to the Facebook and beyond. And after reading the response and seeing the unredacted documentation, I felt I had a duty to obligation to report that to the appropriate people. That was the clerk of the courts, the sheriff of the county, the actual prosecutor of the court of records, or keeper of the records, and then the Lorraine Police Agency that had posted them. It feels like the Lorraine Police Department is upset that I added my professional titles on my complaint. It also feels like they are possibly not upset about my titles at all, and they're maybe trying to just protect their carefully constructed narrative. It also feels like a bit retaliatory in the way they're going about silencing their critics. Please also refer to section 2151.356, sealing of juvenile court records, where it states that the records in cases which a person were adjudicated for delinquent child for committing a violation of 2903.01
or 2907.02 of the revised code shall not be sealed under this section. The juvenile court shall promptly order the immediate sealing of records pertaining to a juvenile in any of the following circumstances: 2151.357, response respecting sealed records, limited inspection. If a court orders a person or a person's sealed pursuant to 2151.356 of the revised code, the person who is subject to the order properly may, and the court shall reply that no record exists with respect to the person upon entry in the matter, and the court, except as provided in Division D of this section, shall do all of the following. Any entry regarding a sealed record or index shall not contain any of the following: Social Security number of the person who is subject to the sealed record, name or description of the act committed, inspection of the records that have been ordered sealed under 2151.356 of the revised code only be may only be the following persons or for the following purposes by the court. Well, so in the end, it boils down to I hereby affirm that, to the best of my knowledge, the above statements are true, and I wish to file criminal charges against James McCann, as he was not acting under color of law when he committed the acts of harassment, nor was he acting under color of law when he released all the information to my contract holder. I also wish charges to be brought against Tim Weitzel because although he received the emails apparently unrequested, he did not act on the knowledge contained within them, and as such, he continued Chief McCann's harassment of Mr. Knapp. He has also then forwarded the information to Tim Green, or at least made him aware, who then stated I could not volunteer as a GAL, and in quote, for the reasons plural, you were told you were unable to contract with the court, which also is retaliatory and conspiracy in its nature, because why is he telling Tim Green anything about me, my contract, or any of that stuff? It should be duly noted that later, when discussing this with Mr. Levesque, he called the courts and spoke with Sarah Tremont, who actually confirmed that I didn't work at the courts, and then gave him information on what and wasn't juvenile services in regards to me. And that should have been directed straight to HR. So these people just take calls, do whatever they want. But anyway, he did not act on the knowledge contained within them, and as such, he continued McCann's harassment of Knapp. He also then forwarded them to Tim Green, as I said, and then which is retaliatory and conspiracy. These types of behaviors of individual public servants are counterintuitive and are not legal. If you see something, say something, is what you always say in the courts. Well, I saw something and I said something, and you did nothing. And again, I say feel free to follow up with any requests that you may have. Then we kind of float through all of this. We're kind of looking at all the stuff I'm going to post online, and a good chunk of all of the complaints that I ever made, um, as well as the response that I made to the city in regards to James's, James's complaint against my license. I mean, again, I have all of these emails and all of these documents in regards to James and everything that's gone on until now. And so, it's just baffling to me that this continues to be, the problem. And this report here that I sent in, is like quite a bit of information. So I will save this report for a later date, which addresses everything, the whom may concern letter. It addresses everything that I sent to my social work board in regards to James's complaint. Because while I can't have his complaint, I can have the questions that were asked of me by my board, and then I responded. And I will go ahead. My next video will probably be me videoing that and putting it online. But for those that say oh, this, that, and the other, and he's not harassing me or anything like that, this is what what you get. This is James trying to send me a friend request. Now he claims he did that on accident, but then you also look at the next page and you go, well, he accidentally friended me and then accidentally followed me. And look right here, these two people. See, I didn't know either of these two people.
And yet both these people at this point were following me on this now page that's gone because I had to delete this page because this was the original page that had my name on it that James came after. So you guys say, oh, well, this, that, and the other. Like, why would a police chief? I don't know. You tell me right there. Followers, Jim McCann. And then he tried to add me as a friend as well. All because it supposedly told him that we were, we'd be good mutual friends. A guy that keeps his page on lockdown, literally thought that was a good idea. So that's kind of where we're at with that as well. And so again, next time around, we're gonna read this citizens narrative and we're gonna go through some of that stuff. But in the meantime, enjoy this video, and there will be more to come. Thanks, guys, for watching, and you guys remember, go check out our pages on Facebook, Lorain County City Politics, Lorain City Politics Uncensored, both political discourse for the city and county of Lorain. I am Aaron Knapp, aka George Patton, your host and guide through all these intricate matters. And I just want to say, guys, make it a wonderful day. And for law enforcement out there, be lawful, not awful.